We're live.
All right, good morning. It is April 16th. We have Representative Priestley with us to discuss H 342, which is a data privacy bill. It's making a pass through our committee, and the floor is yours.
Cool. Awesome. Thanks for having me. I haven't been in here before. Monique Priestley. As this passed through the House, I sent you like an overview documents, and I'm hoping I'll just break down some of the things. I kind of brought this to the building for our committee, and it was based off of the high risk of rates of people who are in positions who are facing people who might have like a higher risk of retaliation. So judges, in this case, so every state is a little bit different. This bill has passed in like 17 other states in different forms, varieties of strength and varieties of the people that they're protecting. Our committee was focused on police and state troopers and people from the court system, Department of Children and Families. We added Human Rights Commission, crisis, mental health workers, and a few others. So there's covered persons as a definition. This was inspired kind of in two parts. One was a judge, federal judge in New Jersey, who has been on the news a lot lately, federally, because of the threats that judges have seen in the climate of things right now. She had somebody who went to her house to shoot her after looking up her address, and ended up shooting and killing her son and shooting her husband as well. He survived. So that is one piece. A second piece for me is just the conversation around privacy, who needs protections, who needs heightened protections, with my feeling that everyone needs privacy protections, but we do need to like start somewhere, and certain people have higher risks. So the overview here is that it applies to just data brokers, so entities who are selling people's information, sharing people's personal information. So this might be an example to give is while we were in committee doing testimony, people were asking questions about like, how easy really is it to get people's information? I went on Spokio for 95 cents and bought everybody's basically access to everybody's home address was on the committee. The time it took to ask like 3 questions. So that is like, if you have somebody who has just received a sentence, is angry, wants to retaliate, it is super easy to go on and buy people's home addresses. We did have an amendment, so the committee passed this out, and then we did have a strike all amendment that was proposed on second reading. And that amendment actually kind of helped blow up the conversation in a way that it gave us time to really analyze the starting bill, and then blowing it up to cover like every bit of information in the universe, basically. So the amendment made it applicable to I guess where the bill started was non-disclosure. So if I am a judge, I want to request from a data broker that my information is not disclosed. So not deleted, but just not disclosed to people who like go on for 95 cents and try to buy my home address, my phone number, my license plate, my social security number. There was an amendment that kind of blew it up to like, okay, let's talk about covering all information in the whole public sphere of everything. Let's talk about covering everyone. Let's talk about not just data brokers, but anybody who sells any type of information at all. What ended up happening was it blew up kind of like the sphere of everything, so that it violated First Amendment, Tort Claims Act, and also public records law. But it gave us a chance to have a discussion of like, what are we actually talking about protecting, from who, like, and what information. I guess that's just cross view, but happy to answer questions.
So I think, at least from my committee's perspective so far, just at first glance, I think our main area of jurisdiction will be the AG and the private right of action. Less so than what, who's considered a covered person. I mean, even though all those people fall into the judiciary category. And I think the rest of it will likely be in Senator Harrison's committee.
Yeah.
So could you speak a bit more on the AG's role in
For
this
sure.
and the private right of action and how you got there?
Yeah, totally. So I also on that document, I don't know if you have it, but I outlined the enforcement mechanism. So we started at just having the private right of action. We ended up adding an AG enforcement mechanism. So how this works is somebody would go onto a form that the AG provides, and in the meantime of the AG not having a form, somebody could do like a written request in writing, physically, or in like email or something, as long as they have the information that's being requested fully. But so the AG enforcement, so if somebody goes on that form and they say like, hey, I really want this data broker to stop sharing my home address. So the data broker then has 15 days after receiving that kind of notice to make a change. If they, this is where it like splits. So then the AG can follow this up with action themselves, or a person after the first 15 days, the person is eligible to be able to bring a private right of action, but the data broker has another 15 days after serving, like being served, to Rick can correct me when he comes on it, very, but basically has like kind of a cure period of such of like 15 days where if they make the change in that period, then the private right of action is like waived, but they're still they still need to cover like attorney fees, like reasonable fees, if or it was filed.
Mosky, did you have a question? Sorry.
No, that's fine. So under the AG, it basically modeled after the Consumer Protection Act in a way, even though this is not a consumer protection bill, and it's 10,000 per violation if the AG does it. If it is through the private right of action, then it's 1,000 per violation, and then they also have access to punitive damages, attorney's fees, and court costs, and equitable relief.
Any questions?
So I just want to make sure I'm clear. So this is, the individual in question has to go to the data brokers and request this.
There's like there eventually will be a form on the AG's website where they go in and say like, here's my name, here's their information I want removed, here's the broker I want removed from, and then that goes to the data broker and they have to
The AG's office sends it to them.
They're just like automated form.
And at that point is the idea that we would be able to list all the data brokers, because there's lots of them.
Right. So the idea is that it like these might come from like these might cover more than just like one data broker at a time. Yeah.
So, and when you say data broker, you mean things like white pages?
So we use the definition of data broker as it's on the Consumer Protection Act, like Title IX for Vermont. And that it's largely like companies who are making the majority of their profit off of like the revenue off of the sales.
Like if I type in somebody's.
I'm not sure white pages like technically. It probably is,
right.
but I'm not sure.
It's the website that's kind of replaced the phone book.
Exactly. Yeah.
For money.
Yeah.
Exactly. So I guess because the internet is such an infinite place, I'm wondering, is this being done elsewhere and how effective is it? So if you have, let's say I could name 5 data brokers.
Sure.
And they didn't disclose the information. I'm just wondering, could a persistent person find it elsewhere?
Yeah, I mean, so that is the question is like, and I think part of this is a start, and yes, and that's so what part of the strike law amendment was to blow it up to be, it was basically that it wasn't just data brokers, it was anybody who sells anything ever, and it was all public information anywhere. So that then that could be, and actually the amendment had you waive basically your rights to be non-disclosed if you ever self-disclose your information. So if I sent you a letter and put my return address, technically that would have qualified as like, yes, there's information out there. I think when it comes to I think the immediacy we heard was like most likely when people are trying, like you could dig and find somebody that is like probably through a bunch of different ways. But if you're somebody who's in like the heat of a moment, kind of like the gun laws, where we're thinking like there's a window where you're extra pissed off and you're gonna like try to like do this, it's super easy to go in like less than 5 minutes and find somebody that is. Yeah.
Okay, thank you.
Sorry, what was-
My question is actually a little bit in line with Senator Bird's, and that is sort of, do we have a sense of how many of these data brokers there are?
So also how I just like broke up for a process in the House was Judiciary heard like the need. And then we heard a lot of the like kind of like data broker technical kind of aspects of the privacy pieces. And I will share all those witnesses, the ones where it expresses kind of the data broker like sphere of what's going on. There's a person, obscure IQ, Jeff Jokish. He has a database of 8,600 data brokers internationally around the world. Most states have something like 700 or so, 500 like data brokers. There's only 4 states right now that have data broker registries. So Oregon, Texas, is it Connecticut and Vermont. California and Vermont are the only 4 that have like data broker registries, and not all, depending on the definition of data broker, they don't always show up in all of those databases either. For example, there's only one in Vermont that I could find in the California or Oregon California, Texas database. There's one data broker who's registered as like having a Vermont address. They're not registered in the Vermont or Oregon database. And from asking Jeff through his database to tell me if there was any Vermont-based data brokers, there was only that one that was active out of the 8,600.
Okay. So would this then only apply to that one data broker with an address in Vermont, or the 8,000?
It would apply to all the 8,600.
But it's on the individual to reach out to the
Exactly.
8,600 data brokers and say, please scrub don't release my data, and then track whether they did it or not.
Exactly.
That's a heavy lift.
Well, yeah. So part of this conversation was that both there are software solutions that can help the data brokers to do an automated non-disclosure request carried out, just like with the data privacy request to make changes. There's also software that helps enable people to make those requests to the data brokers.
Okay.
And so part of this was, getting an argument of frivolous lawsuits because the software that enables people to more efficiently do these requests. And then if the companies don't comply, then they're facing like potentially thousands of requests. And so one of the things we did to address that was one, adding in the AG piece, but then also adding in kind of the time delay, which in some states it's 48, 72 hours that the request goes in and has to be removed. In our case, it's 30 days.
Oh, I'm less concerned with the
Yeah.
burden on the data.
No, totally.
Maybe if they're making money selling people's information, I'm less concerned.
Yeah, totally.
But I was just thinking about, an individual judge
Yeah.
trying to reach out to 8,600 people to keep their family safe is.
Yes.
Yeah.
So part of that was we did hear from Lauren Schultz, through the law professor at MSU, who studies private rights of action in privacy law, and she kind of made. We had the video, and like she's great if you want to hear from her. But she kind of was like making the case for the importance of the private-public relationship when it comes to this kind of thing, because people are basically outnumbered. Yeah.
On the private right of action, this is a phrase that resonates in the building now. We're going through the different iterations,
Yes.
different bills. And if I could ask, in committee and on the floor,
Yeah.
and with the Attorney General, how did that section of the bill play, or what was seemed to be the thinking?
Yeah, so I would say that we spent the most amount of time probably talking about the scope and then that piece. And so that's why we did hear testimony from Lauren Schultz and others to specifically talk about private right of action. Our AG in general is a very strong PRA champion, and had actually just spoken at a New England conference about how PRAs are important in privacy law, like the day we were hearing testimony. So like that piece, they were solid on there. in general, they were fine with adding the AG components, but I think we'll hear from them, but I think they were fine with the private right of action itself as well.
And on the floor, there was,
On the floor, it actually was focused on this blowing up of the bill into a way to just kill it and make it basically apply to everything and useless. And so in committee, we took extra time to actually go through that. And that's when we added more days to kind of the cure period and really tried to think of any different path we could make it so that it is both fair for the person who needs to like take the actions to have their information removed, but also try to like be fair to the data brokers as far as the time it takes to do this, which in most cases, they're gonna have an automated system that does this.
right, which is, I guess, where some of the anxiety comes in about the liability.
Totally, yeah.
You know, and a company that's using an automated system is liable for the system's mistakes. So there's that, but you can see it's pretty sweeping in terms of not disclosing it and being liable and with punitive damages, et cetera.
Yeah.
So definitely worth careful consideration.
Yeah, no, definitely.
So I'm sure this conversation's happened many times, but why, but when we're talking about, so we've got judges, cops, prosecutors and so on, in, you know, that public official bucket.
Yeah.
Why can't we also have a category of just private citizens who aren't particularly fond of the idea of having their private information being used by data brokers? Is there anything, but can you provide an overview on that? Is that doable?
Yeah, I mean, so if we pass the comprehensive privacy law, that would cover everyone. And that's kind of like the struggle to get any of these through for anybody. And so part of this is like an area that it's more of a heightened risk and immediate concern, and people are dealing with it right now, as is everybody. But part of this was trying to hyper focus on like a specific population with specific action that can be taken. But yes, full comprehensive data privacy protections for everyone is ideal, which you guys sent us S71. So
Any other questions?
No, I do have questions about how the list of people was arrived at.
Sure.
It doesn't to me seem comprehensive of everyone who's under heightened scrutiny.
yeah, no, definitely. So we started with kind of what is typical in other states. So most commonly it's judges, and then some others add state the costs and things. Then we started adding, people wanted to add members of the court system and wanted to add crisis mental health workers and investigators. And so the committee kind of like kept adding, both in judiciary and in commerce, kept adding to that list. Actually, when I started with the initial draft, I included municipal employees, but then the state definition of municipal employees blew it up so much that it included like just so many people that would be hard to like prove that to a data broker that person is in a municipal position and whatever.
And
so
school districts are.
exactly. So it blew it up a little bit too much for that, but
I guess my question is, well, I'm looking here, why elected officials are not included.
and so and actually so people did ask that. The primary reason was that other states it's kind of similar to legislative pay, where you're trying to give legislative body trying to give itself something. And so in this case, criticisms in other states of legislators trying to protect themselves for whatever, let you have that conversation. But it did come up and it was just not included because of other states, whatever it's gone through.
It seems, and I'm sure I'm preaching to the choir here, that with the heightened, I mean, we've, seen Nancy Pelosi's husband getting with a hammer. Josh Shapiro's home was just lit on. Like, I've gotten death threats.
Yeah.
Like, I think we're at a space where that information shouldn't be public.
Yeah, and there are also some bills in other states that are focused just on legislators, doing the same exact kind of like act for legislators.
Okay.
Any other questions? Well, thank you.
Yeah, thank you.
Morning.
Morning.
Okay, 8342. Share my screen here. So I think Rep. Christie did a great job of giving you an overview about the bill. I'm going to skip over the findings because that's kind of what she talked about, why the bill was implemented or why it was taken up in the House is covered in the findings. So I want to give you kind of a brief, just kind of overview before I get into the details. And Mr. Chair, you'll have to tell me, how much of the data book or stuff you want to know. As you mentioned, your jurisdiction might be somewhat limited, but I'll let you kind of guide that.
I think if, we'll get a general overview of the bill and if other pieces stick out as probably being our jurisdiction, we can make note of that.
So the main, I think, players in this bill are data brokers. They're the potential companies with liability. You have data brokers. We have a definition of what a data broker is, which we'll go over. You have cover persons, which you all know now is a pretty big group, actually. No state had gone this far. Like Christie said, some states have just judges. Some states have judges and police officers. This bill would include a pretty wide number of people. And it is based off the New Jersey law, which is Daniel's law, where the judge's son was killed. And I'll talk about a court case that has considered that law here in a second. So you have the data brokers, you have the covered persons, and then you have this protected information, which is home address, home phone number, email address. So those are the main things that's kind of in this bill. On page 2, it gets into the substantive discussion, definitions at first. I'm going to skip over authorized agent. That's a pretty common definition. Covered person. You'll note that it includes individuals who are either currently or formerly. So currently a judge, formerly a judge, law enforcement officer, federal law enforcement officer, and some of these are defined later, and I'll go over that. Prosecutor, public defender, parole and probation officer, or member of the Vermont Parole Board. So that's one bucket. Currently or formerly an employee of the Family Services Division of DCF, the Vermont Human Rights Commission, Department of Corrections, Department of Public Safety, including the Vermont State Police, the Department of State's Attorneys and Sheriffs, or of any court in the state. So that sixth one there is also pretty broad. You're saying that any current or former employee of any court in the state would be a covered person. It includes an investigator, victims advocate, mental health crisis worker, or embedded crisis specialist that is employed by or works on a contract basis for any of the entities listed under that subdivision 2. So the DCF, Department of Corrections, and so forth. Again, current or former. It also includes the immediate family of all those individuals. So again, pretty large, right? We're increasing the number of people covered by this by including immediate family, which is defined, and I will show you all what that means here in a second. The data broker has the same meaning as we already defined in state law.
I'm wondering, because I never bothered, to go check what the original definition is. Could that be included? As opposed to just referring to. Sure, because I think what will happen is as people dig into this in the Senate, they will all hit that same point. And the key question is who are the data brokers and how much of a burden is it on them or a liability risk for them? So having that definition actually in the bill would be valuable.
So just for data broker, the other ones, immediate family is not as you think important.
I think that's less. Okay. But I'm curious now to go to section 243 but I wouldn't. You don't happen to have that with you?
I do.
Okay, great.
Yep.
I
figured that might come up simply. So this is Vermont BSA 92430. And this is our protection of personal information statute. So a data broker is a business that knowingly collects and sells or licenses to third parties the brokered personal information of a consumer with whom the business does not have a direct relationship. And then this is not too common, but here we actually give examples of a direct relationship with a business include if the consumer is a past or present customer, client, subscriber, user, or registered user of the business's goods and services, an employee, contractor, or agent of the business, investor of the business, or a donor of the business. So if you have that direct relationship, that's not a data broker as it concerns the consumer. The following activities conducted by a business and the collection and sale or licensing of brokered personal information incidental to conducting these activities do not qualify the business as a data broker. So again, these are kind of exceptions, right, for being a data broker. Developing or maintaining third-party e-commerce or application platforms, providing 411 directory assistance or directory information services, including name, address, telephone number on behalf of or as a function of a telecommunications carrier, providing publicly available information related to a consumer's business or profession, or providing publicly available information via real-time or near real-time alert services for health or safety purposes.
Can I just stop you on the 411?
Yes.
I'm not sure. Is that saying that 411 could continue to provide this information without?
So they would not be considered a data broker. But they would need to be on behalf of the telecommunications carrier. So I would maybe defer to the Secretary of State's office, who data brokers must register with, and see if they have an opinion on if they believe, which list of 411 providers would or would not be considered a data broker.
Because it seems like it would defeat the whole purpose of the bill if 411 was still providing all this information.
Right, but it would have to be on behalf of a telecommunication provider. So I think that's going to limit that scope quite a bit.
Is it because 411 isn't for profit?
Well, it does say or directory information, so I don't want to get hung up on, 411 sounds pretty official, right?
Yeah.
Directory information service does not sound very official. So I want to make sure that, 411 is one thing, but then, Spokio, whitepages.com, as you mentioned earlier, are these directory information services that function on behalf of a telecommunications carrier? I don't know that answer, and I can research that, but I think you'd also talk to the Secretary of State's office to see what their opinion is on that.
I mean, it just seems potentially like it could be a huge carve out that might be pretty counterproductive to what the bill's trying otherwise to do.
It could.
So anyway.
Okay. And then just the phrase sell or licenses does not include a one-time or occasional sale of assets of a business as part of a transfer or control of those assets that's not part of the ordinary conduct of the business, or a sale or license of data that is merely incidental to the business. So one thing, Senator Bruce, about including this definition is this definition of data broker does call a lot of other definitions like brokered personal information that is also defined in the statute. So we define data broker, if we just copy and paste, right, the definition into this bill, you would have to bring over some other definitions like brokered personal information. So just, it can be done.
But they're there anyway.
We've
referenced.
Because we cross-reference 2430, that's acceptable because now someone looking at 2430 this is where it is. And then we have those definitions there. If we just move everything to this bill, we're going to have to bring over all those other definitions.
But I guess what I'm saying is if you reference 2430, as you do here, you don't bring it in.
Correct.
But you reference it. You're also referencing the other definitions.
Correct.
So they're there anyway.
Correct.
Yeah. So whether or not for transparency's sake, we bring them into this bill, they're legally activated, right?
Well, so I guess maybe we're talking different things. If we just bring over this data broker means this, so basically 4A and 4B, C, and D. If we bring those over, that's not going to be enough. We'd have to bring over to what business means.
Yeah.
We'd have to bring over what brokered personal information means. Went wrong over. There we go. So again, it's doable, but we could cross-reference, these other definitions if we remember data broker, but that would be kind of messy. So there's a reason why we did that, just to reduce that.
You're talking about convenience rather than the legal ramifications.
Yeah, and there is advantage to cross-referencing because we may at some point update this definition, data broker. It's a fairly new definition that the state created just a number of years ago. So if we do ever update it, if this becomes law, we would not have to update the data broker definition in this law as well. So
Yeah, I'm just thinking that it seems to me central to the whole bill is the definition of data broker, and if it's not there, people are put to the task of digging it out.
Right.
Anyway. Okay.
Back to the bill. Disclose. Very, very broad definition of what disclose means. It means to solicit, sell, manufacture, give, provide, lend, trade, mail, deliver, transfer, post, publish, distribute, circulate, disseminate, present, exhibit, advertise, offer, or include within a searchable list or database, regardless of whether any person has actually searched the list or database. However, disclose does not include an organization maintaining protected information completely inaccessible and unviewable to any person outside of the organization. So we say disclose, but it means a bunch of other, if you look at synonyms for disclose, I think you would find everything and more as far as what this word means. So keep that in mind too. It's very, very broad.
So no, I just got asked the question, do states, or more importantly, the state of Vermont, sell data?
I can't officially say yes or no because I don't know. But that is states are starting to do that more and more because it is valuable. So I can't say on a record if that does happen here or not, because I don't know.
Okay.
Yeah.
I actually believe Senator Norris, and it's not quite the same type of data that we're talking about. It's licensure data, but we actually have heard from OPR that they would like to be allowed to sell that data. So again, it's licensure data, and it's data that people are asking for access to anyways, and they're getting access to it. And OPR has made the decision that they should be able to charge for that work.
Have they expressed why they want to sell it?
So it's information that is, so again, it's licensure data, it's not personal data,
Right.
and it's information that is needed by entities anyways, like the hospital needs to know who is licensed to practice nursing and who is licensed to practice social work. And so it's data that they need, and OPR is currently giving it to them. They are now saying, due in large part to their budgetary shortfall, they would like to charge for that work.
Wow. Crazy.
Yes.
I mean, since I think that VCIC does the same thing in reference to when they do a criminal record check, they charge for those.
They do.
Yeah. Okay.
So again, it's not exactly the same thing, but there we are in active conversation about the state charging for data access.
Yeah, I just feel like the government exists to provide that data.
Yeah.
All right. Federal law enforcement officer is cross-referenced with the U.S. law, but it is limited to those individuals who work or reside in Vermont. I have the definition pulled up here. On the screen, it is C1. A federal law enforcement officer means any officer, agent, or employee of the United States authorized by law or by a government agency to engage in or supervise the prevention, detection, investigation, or prosecution of any violations of federal criminal law. Home address, which is one of those protected information categories, means a partial or complete street address or other information that reveals a home's location, including tax parcel ID, legal property description, or geographic coordinates. Home telephone number means any telephone number used primarily for personal communication, including landline or cellular telephone number.
Yes.
Yes, Dr. Matos.
Thank you. Thank you, Senator Norris. I appreciate that. Home address. So dealing in real estate, I was going to look up people's lister cards, name, address, parcel ID. That wouldn't be covered because it's a municipality.
Correct.
Okay.
Correct.
So that'd still be public information.
Correct. If it's through a municipality website, through their tax, whatever, however you get that information, as long as it's a governmental agency, they are not data brokers. In fact, our definition excludes government, from data brokers. Now, there's a study at the end that would look at how public agencies could, if they had to apply this law to the government, if they could do it. ADS will look at this and see could this is possible. Could you comply with this type of law if you had to? So there was an earlier version that required public agencies to comply. That was one of the amendments that didn't live. So that is now a study, just so you know.
Because I'm just thinking about, towns post their grand lists, you can go in, look through the grand list, you can look at the list of areas, you can look at it. We even know that we have a zoning regulation tool that you can look up permits that are pulled by people. So if somebody had an idea of what town Phil Bruce lived in, right, just even though he's not a perfect person, but
right. I think it's where Chris said, if someone wants your information, they're going to get it. Like you can't stop that. But what this is attempting to do is make it a little harder. Or maybe not as, you're in that, you get a judicial verdict that's really bad, or you get arrested and you get bailed out, you're mad, that, quick cooling off period. Like, are you able to find that person's information on 5, 10, 15 dollars where you're really upset?
Not to mention that for paid ones, you're in a search up top.
The sponsored ones,
Right. And so, maybe somebody exhausts themselves that was the first page. Yeah. Right.
Okay, immediate families, cross-reference, I just want to show you that definition, because immediate family of a current or former employee of these entities are included. It means an individual's spouse, domestic partner, or civil union partner, child or foster child, sibling, parent, or such relations by marriage or by civil union or domestic partnership, or an individual claimed as a dependent for federal income tax purposes. So, not your cousins, not your aunts and uncles, but, your traditional, what we consider like immediate family is included in this bill.
included in law.
If it's not.
This says or such relations by marriage. So my mother-in-law would.
Well, hold on.
Would my
Because
mother-in-law
this came up in House Commerce, this question. So I think what I thought you were asking was that if you are divorced and your former in-law, it would not cover them obviously, but your current in-law, the parent in my view, I would need to look that up for you.
Or like a brother-in-law, sister-in-law that.
Right. If,
through marriage.
Yeah, let me research that. Because I believe it does cover in-laws because or such relations by marriage. But let me double check that.
So both interesting.
So I fully understand, kind of understand this definition of immediate family. My question is less pertaining to immediate family and more pertaining to household members. Because you may live in the same home with someone and be a covered entity, but actually not be immediate family. And I wonder if there's protection there.
Looking at domestic partner, individual and during domestic relationship or of a spousal nature,
Yes.
that's not going to work.
Yeah, I don't know if it.
I would say no.
Okay.
Yeah, based on this definition.
Okay.
So again, you could come up with your own definition of immediate family. We don't have to cross-reference this one. So if you believe there's a more clear definition of what this includes, or if you want to add somebody explicitly, then you can do that, of course.
When I don't even know if it would need to be a different definition of immediate family, perhaps it's an addition of and household members, because I think the risk. If you live with the covered entity, there is risk to you because you live in the house with them.
So it would include roommates.
Maybe. That wasn't what I was thinking of, but as I started talking about it, it popped into my mind. Like, you just because you aren't an immediate family member or don't have that relationship doesn't mean you're not at risk because you live with that person.
Sure. Okay. Back to the definitions. A judge is really any judge that works at a state court in Vermont or a federal court in Vermont, or who serves as a judge, justice, or magistrate in another state who maintains a home address in Vermont. So you have a judge that works in New Hampshire but lives in Vermont, that judge would be covered because they live in Vermont. Law enforcement officer has the same meaning as in 20 VSA 2351, which I have pulled up. It is this very wordy definition. It's basically every police officer you can think of. I'll let you read that if you want, but it's a pretty standard definition of a police officer in Vermont.
And I feel like I know the answer to this, but just checking. So there's obviously many people who are covered by this, but the only ones who would be truly covered are the ones that apply for the protection.
Correct.
So there's no automatic protection absent them initiating the process.
Correct.
Okay.
Right. A parole and probation officer means a corrections service specialist employed by DOC or a parole or probation officer employed by a Vermont county or municipality. A prosecutor means a Vermont state's attorney or deputy state's attorney, the attorney general or assistant attorney general, or a U.S. attorney or assistant U.S. attorney who works in Vermont. That last one there, these are federal employees, but the decision was made because they work in Vermont. They should be a covered person.
Just a question about that is, will they also have to live in Vermont if they're a federal employee?
So as this one, no. The last section there, the U.S. attorney, or are you speaking just to that category, the U.S. attorneys?
Yeah, so let's say there's a U.S. attorney who works in Vermont.
Right.
They live in New Hampshire.
Right.
This bill would propose to protect their information about their home address in New Hampshire from the data brokers.
Right.
So if a judge, a state judge, is working in Vermont and living in New Hampshire, they wouldn't be covered by this?
They would be covered.
They would be covered.
Yes. The reason why this was added because at first this definition said to not say who works in Vermont. And I believe I told the committee, if you do this, there's going to be Hawaii U.S. attorney, right, that wants to be protected and has no connection to Vermont. So you do want to have some kind of tangible connection. If the committee decided to go with works, you could add and resides. But you may have a few U.S. attorneys who live across the border or who, work across the border.
Thank you.
Yeah. Okay, protected information. Home address, including primary and any secondary residences, your home telephone number, your personal email, your social security number or driver's license number, and your license plate number or other unique identifiers of a vehicle owned, leased, or used on a regular basis by a covered person.
How is it legal to sell someone's social security number?
Well, they may not be selling it, they may be disclosing it, right?
But how is that legal?
That probably is not illegal.
Okay.
Social security number. The dark web, right? Is a place where commerce happens that it's not always on the open up. And this law would apply in that area. But as far as that, these things do happen. And it's hard to sometimes think about that as being like a thing in commerce where this thing happens, but it does. And it's your socials, your home telephone numbers, your email. And I get the alerts where I'm told, my whatever's, I sign up for these alerts where I get my information's available,
Yeah.
Right.
Yeah, I just was, and I appreciate the comprehensive list. I was just having a moment of, do we really need to protect or explicitly say you have to not give this information away if they already shouldn't be giving that? But that's fine. Thank you.
Are federal law enforcement officers protected under this?
Yes. They're defined. I think it's maybe when you stepped out here, subdivision 5 of the definitions.
So if they are living and or working in Vermont,
Who work or reside.
yes.
So I was going to, along those same lines, when it comes to federal judges or federal law enforcement officers, there is no protection presently under the federal system for these individuals.
There's a federal law that was passed just recently, I think maybe 4 or 5 years ago, that says federal judges get protection, not federal law enforcement. So federal judges do get not exactly what this does, but it is similar in that, they're able to request information be removed from the internet. So this would maybe in some ways overlap that, so give them a few more protections if they work under federal judges specifically.
Generally feeling actually less inclined to extend this to federal law enforcement at the moment, but the conversation for another, or perhaps a later time. Senator Bose.
I don't disagree with you, and I guess my question is on how the define works in Vermont. Does that mean they came into Vermont to disappear one person one time, or does that mean they're regularly stationed here? What does that mean?
It's not defined, so bad, so it's protection. I think most judges most courts would say you must on a regular basis be working here, but again, I can't say that for sure, because we can define it if you want. Let's see, where was I? Protect information, public defender means the defender general, deputy defender general, public defenders, or deputy public defenders who provide legal services to persons in need, as set forth in 13 VSA 163. That is just the statutes for public defenders. Okay, now we're into the actual what the bill would require.
Right.
So B1, a covered person or their authorized agent has the right through the section to send a notice to a data broker requesting that the data broker seek disclosure or redisclosure of the covered person's protected information. 2, upon a data broker receiving.
Can I interrupt you?
Yeah.
I'm thinking because you were talking about the difference between selling versus disclosing. Can a person also send a notice to say, stop selling my information?
It would be the same notice, right? It would be
It would be.
whatever the form that the AG provides, it would be that form. And sell is included in that definition of disclose.
Oh, it's
Disclose as, right, like 10 words ago. So yeah, sell is one of those words.
I don't know that I would want to prohibit the sale of my information and allow them instead to give it away for free.
well,
Or vice versa.
It would be,
I think it
it would include, yes, it includes all.
I see it, yeah, right there. Okay, thank you. Yeah, Senator.
So I'm wondering, it says covered person has the right to send a notice to a data broker requesting cease disclosure. Before the AG has the, system set up, does this allow somebody to send an email to a data broker? Would that count?
We have a contingency for that in the bill.
Okay,
There's some language, what a covered person can do before that is available.
okay.
Yeah.
Because I'm wondering what it would mean for them to receive. Because I could see companies saying, we have 1,000 email addresses. It went to an inbox that nobody checks.
Right.
And 2 weeks went by. So I don't know. That's a piece I'm wondering about.
So we do talk about that, not in detail, but it's covered. And also this is a negligence standard. So if somebody does sue and the data broker says, we never received a notice, they can say, yeah, this is an email that is not active. I don't know where you found it. That would maybe not be negligent and they wouldn't be liable. So there is some gray area when it's
Okay.
for the data broker to say, this is not strict liability. This is negligence. And we were negligent. We never received the request.
But in the AG's system that they set up with the notice, that the AG has determined where to send the notices?
So that I do want to correct one thing. It's still the AG will provide the forms, but the person must submit it to the data broker.
How would they know where to submit?
It's a question. The bill doesn't address that.
Seems like a big question. If you're talking about a major corporation, you could spend days trying to figure out.
So let me kind of take a step back for a second. So this is based on the New Jersey law, right?
Yeah.
New Jersey explicitly allowed for assignees to be viewed by covered persons. So there are companies out there that accumulate these claims and will take on 1,000 law enforcement officers or 500 judges, however big the state is, and they'll accumulate these claims, and then they will, on behalf of the covered persons, send notices to the data brokers and can coordinate those claims for a percentage of their recovery. So you'll say, if we do this work, we'll take 30% of the recovery, and you get the 70%, whatever the deal is, right?
If they sue.
Correct.
But what if they're not suing? They're just trying to
So that's part of the contract you make with the entity, right? You agree to terms with this company that does this for their business, and they front the costs, whatever they are, to find these data brokers.
Yeah.
And they send the notices on behalf of the covered person. And then they could also act on a claim in court on behalf of the covered person. So this bill does not explicitly allow a covered person to do that, but Vermont does not require that. So you have the right to contract out your claim to sue to third parties when you want as a Vermonter. So you could do that theoretically, and I imagine if this bill were to pass, that system could be set up to facilitate that, but it's not for me to say.
It sounds kind of similar to a contingency fee process when somebody
Yes.
hires a lawyer.
Yes.
So in other words, if you want to sue someone, you go to an attorney and they offer a contingency fee. It's essentially saying, the lawyer is saying, all right, if we win, I get to take, I guess, 30% of whatever the award is. If we lose, then I don't get anything. And so it's kind of that's kind of the idea that
Yeah. So otherwise, for a person to find the data broker's information, contact information could be difficult. Because the data broker does not have to make that easy, right, to provide. Okay, subdivision 2, upon a data broker receiving physical or electronic notice from a covered person, I'm going to skip saying authorized agent because it's everywhere. Just understand that either the covered person or their agent can send the notice. Requesting that the data broker cease disclosing or redisclosing the protected information. The data broker shall cease disclosing it not later than 15 days after receipt and shall not disclose or redisclose after that time. So this notice shall be in a form and manner provided by the AG. They can determine how that looks and how you get to it, except the notice shall require the covered person provide the covered person's full name, along with the specific protected information of the covered person that is being disclosed by the data broker. No prior verification of the covered person their status shall be required for the notice. And the notice shall include a disclaimer that ceasing disclosure of a covered person's protected information may complicate certain business transactions and may not result in the covered person's protected information being totally removed from the internet. That was added by the House committee to ensure that a person is not just hoping that everything's removed once they do this, that they're going to be perfectly invisible. It's unlikely that would happen. So that's a couple of disclaimers the committee wanted to add. Penalties, AG enforcement. A data broker that receives this notice that then discloses or rediscloses the information more than 15 days after receiving the notice is in violation of the section and shall be assessed a civil penalty of not more than $10,000. So here's the way it works. The person goes to the AG's website, they get the form, they fill it out with their name, the data broker's name, and the information, phone number, address, whatever. They send it to the data broker. Data broker gets 15 days to stop disclosing. If they do that, they're fine. They're in compliance. If they don't do that, on day 16, the AG could begin enforcement, investigation, whatever they want to do. That could result in a civil penalty of not more than $10,000 for each violation. So the AG has the same authority to adopt rules and conduct civil investigations, standard AG language. C, the AG shall create a form on its website where a covered person or their agent is able to provide notice to the AG that more than 15 days have passed since the covered person submitted a notice, and the data broker continues to disclose or has redisclosed the covered person's protected information. So this is a second notice, and I want to get confused. You have the first notice that you sent to the data broker. Then the AG provides the second notice that the covered person could use. They don't have to do this, but this is a way for the covered person to tell the AG that, hey, I sent them this notice. They have not stopped disclosing it. And the AG requested this so they're able to accumulate this information. And if there's one data broker that they've noticed, hey, we've gotten 30 notices that this data broker is not removing information, perhaps we should begin investigating this one data broker. So this is a way for the AG to kind of learn, because they don't submit the claims. Remember, the person submits the claims to the data broker. This is a way for the AG to understand how many claims are being submitted, how many are not being responded to. That's all.
I think I'm slightly confused as to what the flow chart would look like. So a covered person sends a notice through the AG's website. And-
Well, let me stop you. They download the notice, they fill it out, but then they must send it to the data broker.
Okay.
Yeah.
And then the data broker, let's say they ignore it for whatever reason. 16 days later, the information is still being disclosed. Is that data broker now liable to both the AG's enforcement and the covered person, or which one first?
Definitely the AG.
Yeah.
Definitely the AG. There's a safe harbor, we'll get to it in the private action. But definitely the AG on day 16, they are out of compliance with the law and subject to enforcement.
Is there, this might be a question for Representative Priestley, but is there a reason that it's the AG first and then the covered person or the injured person, rather than having them both have the ability to enforce and sue?
Well, you can do both. Like, so on, maybe, can we get, maybe if we get to the private action?
Oh, yeah, am I getting it? Okay, yes, yeah.
So right now, we're just talking about enforcement, right? So on day, so this is now, so the covered person, they send the notice, right? They don't do anything. The AG on day 16 has a right to enforce, but we have this subdivision here, C, because how is the AG going to know that we have a problem? So this is a second form the AG provides that allows the covered person to basically tell them, hey, we have not had information removed yet. It's still being disclosed. So the AG receives this and they can use that how they want. They can use that as, you know, we have so many claims against this one data broker, or we have this one person that has these, that sent out 20 notices and neither of them have been needed to, right?
And for the AG, is it essentially strict liability and then negligence for the private right of action, or?
The civil penalty typically is strict liability, when it comes to enforcement. But I think, let me clarify that. That's a good question. Yeah, I've never thought of it that way.
Senator Bruce?
So the clock starts running when they receive the notice. Right. And back to my question, how do we define when they receive it? Is it, if it's in the form of an email, I don't know, it seems like it would be, since neither the AG nor the bill nor the government is directing where these complaints should go, we're just saying you have the right to email companies, thousands of companies. And so it seems like it's just so imprecise to be able to recover punitive damages for an email that went to a wrong inbox. Or so if I send to an email at White Pages and it's somebody in the legal department, but it's not the person who does this or that, is it automatically the date that I send the email begins the clock running? Because it says upon a data broker receiving, or a data broker that receives a notice has 15 days. And I just don't know when a court would come down on the question of when was it received?
So it would typically be the time it lands in the inbox. If it's an email, if it's a physical letter, it'd be the time it's received in the mailbox of the data, or not when they read it, time of receipt.
Yeah.
That's typically in law, the way things are written. We can define that. We can further explain how that works. But it's a good point that you know, data brokers may have issues with that and may not be able to receive the emails in time, may not be able to coordinate that in time.
Because I have 3 emails, a campaign email, I have a work email, and I have a ledge email. And I have stuff go missing all the time because all of those emails also have spam filters that direct them to several boxes. And it just seems like we're setting up a system that depends on a clock running, but without a reliable start time.
So you do have a data broker registry in Vermont, but it's only for Vermont data brokers, right? That are doing business in Vermont at least. And it's a very quick and easy registry. It's not anything, there's no regulation of data brokers. It's just you must register with the state. I don't know if that contact information gets updated enough, but that could be something you think about is, do you want the Secretary of State, which controls that, filing, do you want them to be involved in this? They were originally in the early version of the bill, but then the AG got brought in. And so we kind of directed into the AG. You could have that office coordinate somehow. But again, you're talking about a data broker in Oklahoma. It's not going to be registered likely in Vermont, and they would not have that information.
But to that point, I mean, can we make it a requirement to send it to the data broker's registered agent? Because, you know, the data broker in another state presumably is going to have to be registered in with their Secretary of State. And I believe every business is going to have to list who the registered agent is. And they have to maintain their information, their contact information is public, and presumably they have to maintain its accuracy.
Presumably, yeah. Now that would be a way for the data broker, I think, maybe to have it more easily found. But now the covered person is going to have a harder time finding, what's the LLC, what's the corporation, is it a general partnership, is it a sole proprietorship? Senator Mattis, about all that.
I sure do.
Organizations now, and then you have to find out which state they're in, and that could be complicated too.
Yeah, I think to Senator Ruth's point, there could be issues when a person is trying to find, email, and they send it to, just the customer service link and or the email, and maybe it's outdated. Maybe somebody just isn't checking it, and then, that's going to have to proceed. In litigation, it'll have to be proven by one party or the other that, this is an active email address or it isn't. And, notice was or wasn't served properly. I mean, it would tie things off. And I think making it more clear. I think if somebody is going down the path of saying, all right, I want to figure this out. I want to reach out to the data broker. I read this law. I looked at the AG's website and it's saying I have to find a registered agent. Okay, what's a registered agent? And then, they start doing they start trying to track it down. But yeah, those are just some initial thoughts.
Good questions. I mean, that part could get complicated, and I'm not sure how I believe New Jersey has, and maybe our prison this more, they have a system set up, is that where the data brokers must register with the site, or no, it's the public agencies. There's a system they've created, the state registry that I think helps facilitate this process, but I can't speak to, how that works and if it works well, if it's even helping either side.
This actually might be a question for Representative Priestley, and that is if we know anyone that could answer some of the questions about the New Jersey registry and how it's working. And because I do see the point, which leads me to thinking maybe we need to do something similar if that is working.
Yeah, so definitely. So if the witnesses that were heard in both House Judiciary and Commerce, and then additional ones that we're going to suggest as well.
Okay.
Yeah.
I realize this is a different walkthrough or whatever else, but it's almost seems like we'll go down a rabbit hole here as far as the technicality and enforcement of this and how many data brokers we have worldwide, and we've got the right to sue for $1,000 or the attorney general for $10,000. Who's going to follow up on this? And as an individual, I'm supposed to know or notify all these data. How much time in my lifetime do you have to do all this? That's more or less to locate them and then notify them in writing or whatever else. So I'm just curious as to how effective this bill will be looking at it.
Yeah, and that's why we're raising our points during the markup or during the walkthrough. And we can revisit some of these issues as we get the markup.
All right. So we left off about the form where the covered person tells the AG that the information is still being disclosed, right? So subdivision 2 is the private action. subject to the requirements, in subsection B, we'll get to in a second, a data broker that receives notice from a covered person and that discloses or redisposes the covered person information more than 15 days after receiving it. So same thing, right? It's been 15 days, they still disclose it. The covered person may bring a civil action in civil court against the data broker for damages, calculated as the greater of actual damages or liquidated damages, computed at the rate of 1,000 for each violation. So I think this committee probably knows liquidated damages. That's just this bill is telling the court this is what this is worth, right? It's $1,000. Commonly used in complicated contracts where it might be difficult to determine the harm done by a breach. Here, it's kind of difficult that your information's out there. What is the harm of that? Could be a couple bucks, could be worth a lot if it leads to violence or leads to some kind of stalking, right? Those things. Punitive damages upon proof of willful or reckless disregard. So a very, very high standard that if the data broker is just blatantly ignoring the notice and is acting, willfully, recklessly, then there could be extra punitive damages. Reasonable attorney's fees and other litigation costs recently incurred, and any other preliminary and equitable relief as the court determines, like an injunction, could also be granted by his validity. So this is the safe harbor protection. A data broker that ceases disclosing the protected information of a covered person not more than 15 days after being served with process, meaning that the covered person has gone to court and filed a lawsuit. The data broker then gets sued, right? They get served with the papers. Shall only be liable to the covered person for reasonable attorney's fees and court costs. So they get served, and then within 15 days, they stop disclosing. If that happens, then the data broker is only liable for attorney's fees and court costs if the court determines that to be a proper remedy. Does that make sense, that part? A data broker is not eligible for this safe harbor if the data broker, more than 15 days after notice from the covered person, way up at top, that initial notice, they disclose additional information. So this is kind of a retaliation. Data broker gets the notice, and they not only do they not stop disclosing, they then disclose additional information. So if they're just disclosing your home phone number, now they disclose your home phone number and your home address, let's say. They would not be eligible for the safe harbor. Or they redisclose protected information after having received notice. So they basically, they get the notice, maybe they stop, for, let's say 2 months they stop. But then they do it again, they redisclose. Then they would not be eligible for the safe harbor if you ever decide to sue that data broker. Any questions about the private right of action? So
One more time, can you just reiterate the safe harbor piece
Right.
one more time for
Yeah.
me?
So covered person files a notice to the data broker. So they send the notice, data broker receives it, and let's say they don't do anything, right? They keep disclosing. So on that, after 15 days, the person decides to sue. So they go to court, they file a claim, and they get the data broker's agent served with process, right? Once they're served with process, within another 15-day window, if they stop disclosing the information, the covered person is only eligible for attorney's fees and court costs. So whatever that, at that point, the cost that they've incurred, right? That's the safe harbor. And there's a couple of exceptions to that, but that gives the data broker, I think the idea is to give them an incentive to stop disclosing information.
Okay, thank you.
And Mr. Chair, I answered my own question. Your question earlier, the subdivision 3, I thought only pertained to the PRA, but also includes any judicial proceeding, including AG enforcement. So 3, in any judicial proceeding, the standard of fault shall be ordinary negligence. So if the AG decides to enforce, it's not strict liability, it's just something, it's negligence. It is not a defense to liability that the covered person's protected information is or was available to the public from other sources on the internet or otherwise. So if a town is producing your home address, like most towns do, right, on their grand list, that's not an exception for a data broker to say, well, it's already out there. They still have to stop disclosing. D, accessing information, a covered person that access a data broker website or other application for the purpose of determining whether the covered person's protected information is being disclosed shall not, as a result of such access, be deemed to have agreed on behalf of the covered person to any website terms and conditions with respect to their rights. So you don't want to have a data broker have a checkbox on there that says you agree you made any right to sue or right to have your information removed. That would remove that possibility. Limitations. A disclosure of protected information shall not constitute a violation of this section if the disclosure is A, made with the express or standing authorization of the covered person, provided the authorization is provided subsequent to the relevant non-disclosure request. So this was brought up as some financial transactions. If you are trying to buy a house, if you are trying to get a loan, it could be that the lender needs to do a background check, credit check, right? Make sure that you are qualified for the house, qualified for the loan. If you provide authorization that I grant you the authority to disclose this information for this purpose, that's not going to run afoul of the statute. It's going to be an exception to the statute. And B is kind of more of a catch-all for the sole purpose of facilitating a transaction initiated by the covered person. So again, if you are doing something that you have agreed to do, and if that something must be disclosed, your home address, your home email, whatever it is, for that transaction, that's also excluded from the bill. This section does not apply to a data broker, any disclosure pursuant to subdivision 1 of the subsection. So a data broker that is included in that disclosure, they are not included in that exception. Yes. Nothing in the section shall be construed as prohibiting an employer from providing employee information to the Vermont Labor Relations Board or to an employee organization that is required under Vermont law. Nothing in the section shall be construed to require a data broker to delete protected information. So disclosing does not mean cease disclosing does not mean deletion. Those are two different things, right? Of all the words that we have as disclosed synonyms, delete was not one of them. So the idea here is that if a data broker has information that it's not disclosing, that has behind some kind of, not even a table, but they have information, but it's not publicly available or available at all. The data broker does not have to delete it, they just can't disclose.
So earlier in the discussion, it's not covered if a data broker sells all their information in a one-time transaction. That's carved out, as I remember.
They sell, well, typically, and you may want to hear from someone who maybe does these kind of transactions, but if you are trying to, buy a home or some kind of major credit.
No, I mean the data broker sells their whole database.
Oh, okay. I see what you mean.
As I remember, that's carved out. So
they sell their database because they're just out of their.
Yeah, it's a one-time.
Right.
So let's say you've reached out to a data broker. They've stopped selling your information in that case, but they could sell their whole database.
Right. Because
They're retaining the information.
I see.
They could sell their whole database to another broker you didn't reach out to, who could then post your stuff.
Correct.
It's not that they would be interested in you as an individual, but that could happen.
So you would have to reach out to that new data broker, right, and have that information stop being disclosed to you,
Right.
correct?
So all the way of saying that the internet is like kudzu and, it's going to come back in one form or another.
It could happen, yes, yeah. Then you have some session law here, the form of notice. This is the AG, more information about that notice. And what the Senator Ruth earlier asked about the covered person, if there's no notice available. So the AG has 90 days after July 1st of this year to produce that notice. However, the bill is effective July 1st, 2025. So provided that until such time the form is published, covered persons and their agents may use their own form of written notice that 1, references this section, identifies the sender as a covered person, or as an authorized agent, provides the covered person's full name along with the specific protected information of the covered person that is being disclosed, and requests that the data broker cease disclosing the specific protected information of the covered person. But ideally, this is just relevant for until I'm not going to map it, but September 1st, whatever 90 days after July 1st is. Section 4 is the study that ADS will conduct about how this bill might apply to public agencies. Again, New Jersey just recently is requiring their public agencies to comply. So ADS, in consultation with the agency administration, the Office of Secretary of State, the Office of Attorney General, and with other state agencies as requested by the agency, shall conduct a study to determine the various considerations and impacts on state public agencies if public agencies were required to conform to the disclosure policies set forth in this act. The agency shall meet with and receive input from relevant stakeholders in conducting the study, including the Vermont League of Cities and Towns and the Vermont Municipal Clerks and Treasurers Association. The agency shall consider the following. If public agencies were required to cease disclosing the protection information of covered persons, the extent to which they could currently be able to accommodate those requests, the fiscal and resource impact on these agencies, whether additional staffing or training would be needed, the degree to which risk can be mitigated from state or local policy, and determining which statutes, regulations, and administrative policies require amending to accomplish this goal of removing the information. How other states have implemented similar requirements on the public agencies, the feasibility of creating a state office to manage all statewide requests to cease disclosing protected information, and any additional related areas of study as determined by the agency. The report we would do on December 1st, 2026, and would include recommendations for legislative action and policy modifications and a timeline for implementation on public agencies. The private action is delayed until January 1st, 2026. So the bill's effective July 1st, 2026, and the AG enforcement can begin in July. But the private action, they're given 6 months, data brokers are, to hopefully figure out a way to comply to avoid civil action brought by people.
Got it. Yeah. Any questions?
Just have a general one. How would I know who the data broker is? Like, how would I don't ever know
Yeah.
who's got my data.
They're not really household
Probably
names.
is that.
No, I mean, you probably heard of Zillow. They're one of the bigger data brokers. But a lot of them are not household names. And like I said before, there are companies out there that do this type of work. And even today in Vermont, you can, pay one of these companies to provide you a list of companies that are disclosing your information, right? So you can get that list from a company and then act how you want. Or, yeah, you could research and.
No, I'm doing it right now. Like, I don't know. Like, yeah. Spy dialer. It's inactive.
It's a good question. If you send these notices to what you think is a data broker and they're not one, you're never really going to know. If it's still on there 16 days later and you decide to sue that company and they're not a data broker under Vermont law, then you would possibly have that money in hiring a lawyer and paying the court costs. So that could be an issue that you might want to think about.
Because I know you sign up for stuff all the time. And where that data goes, I'm sure you click a box and it says, just okay.
Probably why New Jersey made it explicitly allowable to have assignees that are trained to do this stuff and know how to do it and have procedures in place to make it more streamlined. And that's my opinion, that you could do this here in Vermont, but you could also be explicit and say people can assign their claims to third parties per contract law.
Any further questions?
No, I was just gonna say it's one of the questions in the data broker registry. Does this data broker permit a consumer to authorize a third party to perform the opt out on the consumers that have. Yes. Has all kinds of data, email address, who it is, where it is.
Yeah, unfortunately, it's only for Vermont data brokers, right? So a lot of these data brokers that, because on the internet, they could be in Russia, right? You don't know where they're located. So a lot of these companies don't register with Vermont. So the ones that register here, yeah, maybe you have good information, but the ones that are in California, New York, you may not be able to find their email easily. Because only a handful of states have data broker registers. It's us, California, Texas, and another state has that.
Oregon, Texas, California.
Yeah, so still kind of hard to find it where these people work and exist.
You said in Florida?
No, Oregon, California, Texas, and Florida.
Well, this is like a Florida business, Washington, Virginia, Massachusetts, New Jersey,
Some of the bigger ones may register in Vermont to,
just to cover it.
yeah, they're supposed to. If they do business here, they're supposed to.
Right. Well, we'll be getting more testimony on this from different witnesses, and we'll also probably have the AG at some point. Yeah, thank you, Rick.
Thanks, Rick. Yeah.
We'll be taking up H98/S95 at 10:45. So if folks wanna take a break,